Thank you all for being at our first Small Business University of the year. And as all of the series will be this year, it's presented by Payroll People. And we have Craig Donaldson with us to say a couple words about Payroll People, but they're a great local company and a great partner of the Chamber, and can't recommend them highly enough. Craig, the floor is yours, sir.
Scott, appreciate that. You guys hear me okay?
Yes.
Um, First of all, I just want to say thank you to the chamber. You guys are wonderful ambassadors to the Fresno area. A little bit about the payroll people. Um, we are celebrating 45 years in business this year, and we deliver powerful platforms, um, support expertise, and systems that are designed to um, allow you to track the life cycle of an employee from their hire to their retirement or separation if that happens in the meantime. Um, we're in business to make business easy for our clients. With that said, always happy to have a conversation with anybody who might be interested in learning more about our services. But we are honored to present Ian Whelan and the topic today, um, and can't thank the Chamber enough.
Thank you. Thanks for your support of this series. It's as the attendees hopefully know, we'll be doing them throughout the year on topics that are important to local business. This is always our kind of our most popular one of the year, and I feel like one of the most important ones of the year. The state of California really does not make things easy on business and small business. And when it comes to HR law, there is really the leader in our market is Sagasser, Watkins and Wieland, and the leader of Sagasser, Watkins and Wieland is our friend, former chair Ian Wieland. So grateful that you're doing this again with us this year, Ian, and the floor is yours, sir.
Thank you, Craig, and thank you, Scott, and thanks for the Fresno Chamber of Commerce for having me today. Good morning, everyone. I'll just dive in. So the topic of the day is new employment and labor laws for 2026. This is one of those things where it's January 7th, and most of the things that we're covering today took effect January 1. Just be sure we jump on making sure we're compliant with a lot of these things. And I'll just say before we dive in, a couple of things. One, as we've talked if you've attended these over the years, the number one threat to business has been and will continue to be this year and in the foreseeable future, like wage and hour. So making sure you're paying employees correctly, meal and rest breaks are, properly taken and offered to employees and all those sorts of things, because the labor code is just black and white on those things, and you're either doing it right or you're not. And we have PAGA claims and wage and hour class actions in DLSC, and I spend a lot of my time, defending those. And so just make sure you're buttoned up there. And then as you'll see, as we go over these things, there's just a lot of changes to policies, in employee handbooks. And I still get people, like even a few in the last few weeks, that come to me or the law firm, and they don't have employee handbooks. And even if you have five or six or a handful of employees, like at this point in time, being 2026, you really need to have an employee handbook, because as you'll see as we go through some of these things, there's a lot of requirements where you're required to have policies, and you're required to give employees notice of your written policies. And it's just easier to have an employee handbook. And if you ever have an issue with a plaintiff's attorney or a government agency, at the very beginning, they're going to ask you for your employee handbook. And if you don't have one, that's just a major red flag, and you're kind of coming coming at it from a bad start. So just, make sure you get one of those. And, before I forget, as part of being a member of the, chamber and a participant today, the chamber does have the, labor law posters. And that's an easy way to post in your employee break rooms, all the, laws that you have to do. So it's easy to get a copy of the chamber poster. Quite frankly, that's what we do at the law firm. We just post it. So, if you need one of those, make sure you reach out to Scott and Gina and team and get one. But at this point, we'll just dive right in. And I know we have a PowerPoint that we're going to go over. And there's quite a bit of material. So if you have questions, feel free to go into the, chat box and, ask questions, and we'll try to answer those as we go along. At the very end, there'll also be Q&A. So let's go to the first slide, which is minimum wage increase. So pretty straightforward in just, what we should be accustomed to in California is every year there's, unless the legislature and the governor make a change, they do forecasting in August about kind of the consumer price index and kind of look at where things are going to be, and they, then adjust the minimum wage. And so this year, it's 16.90. Now, obviously, if you're in a certain industry that has a higher minimum wage, like health care industry or the fast food industry, that's going to be different. And I'm assuming most of the folks on today are like in Fresno, but there's other counties, other cities that have higher minimum wage requirements. So if you also have businesses, locations in those counties, make sure you're complying with those minimum standards. And this one seems like, pretty straightforward, but every year, in mid-January, late January, early February, we get, a couple phone calls where people forget that when the minimum wage goes up, the salary exempt threshold, 2 times the minimum wage also goes up. So just, be aware, it's now 70,000 in change if you have exempt employees. So make sure you're complying with that. And like just one practical issue that's come up is as the minimum wage has gone up, the default under California and federal law is to pay employees hourly as non-exempt, keeping track of their time on a time card. And obviously, if people meet the exemption, you can do that. But I've had some clients over the years where they've taken some positions that technically could be exempt, but just because the cost of minimum wage for certain, middle management or mid-level roles, it just doesn't justify paying these higher salaries, and they've switched, salaried folks to hourly. So just one thing that we're seeing more and more is the minimum wage goes up. And there's a question about the slideshow. Yeah, after I think after the presentation today, the Fresno Chamber will send the slideshow PowerPoint around, and feel free to use it. Let's go to the next slide. So ban on stay or pay contracts. And so this is one that, just irked me because it's something that actually impacts, something that we do for employees at the law firm. And I help clients, throughout different industries do this for, employees. And basically what it is, and it's written, broadly, is it's starting January 1, employers are prohibited from having a contract term that requires an employee to pay the employer for a debt, if employment ends, authorizes the employer to collect the debt if the employment ends, or imposes some sort of penalty or fee or cost to the employee when the employment ends. And there's limited exceptions to it, but generally, where this has come up historically is sometimes we'll draft relocation agreements, or retention bonus agreements where we are trying to attract an employee to come to the company, and maybe they're moving cross country or they're moving within the state, and we're saying, hey, we're going to give you, we're going to pay for your relocation and a retention. But if you leave if you leave within a certain time period, it could be 2 years, a year, then you're going to owe back um, on a prorated basis, you know that amount that you leave early on, you're going to owe the employer via business. The other common example of this is something that we do at the law firm is, we've had paralegals that have come to us and say, hey, we want to finish our paralegal degree, or we have staff that want to become a paralegal. Hey, will you guys help us in loan, to go to paralegal school and pay for that? And we've, entered into agreements where, yeah, we'll do that. But if you got to stay here for a period of time, and if you don't, then you owe us the differential. And I have a lot of clients across industries that have done that for educational, purposes. And so the problem now, and now if you have agreements that were enacted prior to January 1 of this year, like those are good, but just moving forward, we can't do that. And this is kind of one of those things that, what are you doing, Sacramento? Because it's really something that I think hurts the employees, because really employers in this situation when it comes up is, with the educational loan agreements, we're trying to help folks out. Don't necessarily need to, become the bank of the, business, but we're trying to, encourage folks to get educated and, do well within the company and move upward in the company. I really don't see the downside, but obviously, California says we can't do this like that moving forward. Now, what you can do is you can have a separate standalone loan agreement with the employee that has nothing to do with employment. Downside, obviously, though, is if the employee leaves, it's just a straight up loan agreement, and so you would have to collect on it just like you would loaning anybody, and it can't have anything to do with the employment. It's got to be outside of it. So just FYI there, if you're using any of those types of agreements, be aware of that moving forward. Go to the next slide. So, California WARN Act notice. So hopefully this doesn't apply to anyone on the seminar today. So because if you're having to call an attorney or reach out to HR, regarding a WARN Act, it's just not a good situation. It's because under federal and California law, if you're laying off more than 50 employees within 30 days, or you're shutting down your business, we have to give a 60-day, WARN Act, notice under California and federal law. And so basically, there was a change in law that states that we have to add additional things to that notice. And so this is just one of those things of making sure, if you're in that unfortunate situation of having to do a mass layoff, reduction in force, or you're shutting down a company or a location where you're triggering WARN, just make sure you're using the current notice. Like sometimes I see people go to ChatGPT, or they go to the Google and pull off some random thing that's not, updated. So just make sure you're using the current one. And of course, if you want to make sure you're doing the right thing, run it by your, HR and legal counsel. We'll go to the next slide. So this is one that I'm just flagging because, I think a lot of us, including myself, were kind of like, why are we still talking about COVID-19? But apparently they are in Sacramento, and they, in case you forgot, there was a priority that employees had, that if they were, needing to be recalled or reinstated because they were laid off to COVID-19, that's being extended until January 1 of 2027. Now, I mean, like the practical reality of it, right, is we're so far down the road past COVID-19 that I don't think there's going to be very few situations where someone's trying to come back to an employer or a business that was laid off, due to COVID-19. But just keep in mind, just what your big takeaway from this slide is, hey, if you do happen to have somebody, that comes to you and they were laid off because of COVID-19, that should trigger something of like, maybe this person gets some type of priority if I'm rehiring. But obviously, as time is going on, it's less and less of a thing. So just more of an FYI, and I think it'll have limited application. We'll go to the next slide. So strengthening pay equity laws. And so, we've had pay equity laws on the books in California for the last several years. And this year, the legislature and the governor, passed and signed legislation redefining and tweaking it a bit. And as you would expect, to be more, pro-employee, not pro-employer, but and so like previously, one of the aspects of pay equity laws is having a pay scale. So as an employer, as a business, if you're advertising for any position, any job, any opening, and an employee requests a pay scale, we are required to give a good faith pay scale of what the salary range and hourly rate range of that position is, right? And and so basically, one of the changes here is redefining the definition of what the pay scale and a good faith estimate should be. And so just be mindful of it. And so, obviously, the way that I've handled this with clients and also at the law firm is obviously there's going to be a scale based on experience, and there's entry level versus folks that have been doing it for 20, 30 years, right? And so, sometimes, if you're going to post a position, you got to be mindful of what you're actually doing and what the, local industry might be doing, but more importantly, what you're doing and kind of posting that. And obviously, if people have questions, they have zero experience or they have 1 year experience, versus someone that's, been doing it for 20 plus years, like that's going to be a difference in pay, right? And so, in from a practical standpoint, just something to be aware of. As a employment defense attorney that not only does general labor advice all the time, but I'm also a litigator. We thought there would be more litigation over these issues, and knock on wood, just haven't really seen it. So just, make sure you're compliant and you have a pay scale and you produce it when it's requested. And I realize with smaller businesses where maybe not having these ready to go, but just be aware that if someone does ask for a pay scale for that job opening, that position, we do need to provide it. We'll go to the next slide. So, and again, strengthening pay equity laws. So this is, redefining sex, which is what, has been a consistent theme in Sacramento. And so the previous legislation basically said opposite sex, and now that's been changed to another sex. So basically looking at, how, individuals might define, what their sex could be, because obviously we have, multiple, definitions these days. And so, like where this is more common, where I've actually seen this is from the federal EEOC, a couple from, what used to be called the California Department of Fair Employment and Housing, now called the Civil Rights Commission, the state and federal agencies that are tasked with in enforcing harassment, discrimination, and retaliation laws. Is, we've had a few matters where they're looking at pay equity issues and how we're paying employees. And so, I would look at it from, the perspective, and this is what I do when I'm advising clients and also at the law firm is, can we justify, discrepancies? Because the law is basically you shouldn't be paying, wages of, another sex, differently unless you can justify it, right? Like this employee's been here 20 years. This employee has been here year or two, right? This person has these different things, right? And so whenever I'm looking at our compensation and I'm helping clients with these issues or I'm defending these cases, always make sure you can justify it based on legitimate business reasons. And like, by the way, and even though we don't see it very often, these sort of claims can come up, based on race. Why are you paying this race more? Older workers, younger, workers, sort of things. And so I always kind of look at it like, hey, can we justify this, if we're ever challenged? And most of the time you can. And if for some reason you can't justify it, then maybe you need to look at it and make some adjustments. So yeah, we can go to the next slide. So expanded So I just got a question. The question is, so for this, if I have a male manager and a female manager, they must be paid the same regardless of time of service or skill. And so I think I answered that one earlier. Obviously, if we have differences based on experience and skill level, those are legitimate, business reasons that would justify why they're paid differently. So personnel records. So under California law, I'm going to talk about this more broadly and then narrow in. So under California law, we have to keep employee personnel files. There's statute of limitations going back 4 years. We recommend that you keep all employee personnel files, pay and time records going back 5 years. A lot of the potential statute of limitations can go back four. I always say five just so we have a cushion there because I've had some clients with their retention policies like cut it off too early. They're doing 4 years and they, cut it off too early and we only have 3 years and 10 months or 3.5 years. And so it's just always better to have a cushion on that side instead of cutting it too short. But specifically for personnel records. And so where this comes up a lot is employees under the California Labor Code, they have a right to inspect their personnel file. And as a cynical defense attorney, which I am, this is a new law that, to be just blunt about it, the California plaintiffs bar, so the folks that I battle against all the time, the plaintiffs attorneys and the unions are the two biggest lobbies in the state of California, and so every year they go to the legislature and they advocate for pro employee legislation. Well, they also advocate for legislation from the plaintiffs bar to make their job easier and quite frankly my job harder, and then more obligations on you to like trip it up, to like help try to trip you up, to try to poke holes in what we're doing and create a case or issues for their cases, right? So this is one of those that they advocated for, and this is why we're talking about it. So under prior California law, we have to make the personnel file available to the employee for inspection, or give them a copy if they pay for the reasonable cost of production. And so, like literally every day in my law firm, we get these requests from plaintiffs' attorneys, and normally they're fishing. They're fishing to see if they have a case. And so, the new obligations that were required as part of, the personnel file, production and record keeping is making sure that we have the performance reviews in there, and education and like training records. And so I think the training records, education records is going to be more of a pain, for different industries. We're doing, it could be Cal OSHA safety training. It could be all sorts of things. And obviously we have to maintain those records for Cal OSHA and safety, purposes. And so this is just, one of those things like moving forward when we get a personnel file request from an employee or a plaintiff's attorney, the training and educational records are things that are going to need to be included as part of that production moving forward. So just one more thing to be aware of and that we need to do moving forward. So there's a question for the minimum wage. How does that impact commission pay? So kind of depends on how the commission pay is being done. So basically if it's an outside salesperson, that's an exempt outside salesperson, they're not really impacted by the minimum wage. But if you have an inside salesperson that has to be paid at least the minimum wage, you need to make sure that they're making the minimum wage for all hours, just like someone working piece rate. If someone working piece rate, they have to be paid at least the minimum wage. And so if someone is, unless they're an outside sales person who's exempt, and they fall under some other exemption, most people are going to be, again, hourly non-exempt employees. And even if they're paid commission, they need to be paid at least the minimum wage for all hours worked. So another fun notice. So, this one got a little bit more news, but basically all employers, by February 1st of this year are required to give a new notice to employees, and it's got to be a standalone notice about workplace and constitutional rights. And some of this stuff, it's already in the labor law poster. It's already out there. So again, why do we need to do this? But it is what it is. And the state of California, the labor commissioner, is developing a template, and there's a lot of, trade associations and groups that have sent out a template. We have one at the law firm. I would just, put the bare minimum that's required, and so some of these things, obviously, we can see it's a bit political coming out of Sacramento. Skim the Times are in, like, right to notice of inspection by immigration agencies, right to organize a union. I mean, I'm not sure why we need to do that, but that's in there. So obviously there's a clear bias, but it's a notice that has to be given to employees. And so, I've had a few clients upset about it, but like the reality is, for new hires, it's just going to be one more piece of paper that we're giving to the employees as part of the onboarding packet. For existing employees, it's just another thing that we can roll out when we're, having them, review and acknowledge new employee handbooks and arbitration agreements and all those sorts of things. And so I think it's like a lot of the stuff that we're having to do and give the employees. It's just one more thing. And I think there's so much of this now, it just kind of gets lost and everything. So I wouldn't make a big deal about it. Just, do it and move on. And, obviously we have to, what I would do, because we're required to give this to the employees, is I have, clients that are giving it out and, maintaining a record of what was provided and when. The other way to do it is they're having employees receive it and sign a notice of acknowledgement, signing and dating the form that they received this. So there's a record that they actually provided it. I think that's a good idea, just to make sure, either way, just some record of you doing it and that we did it. So if you're ever questioned that you did this or not, that we can defend it for you. And go to the next one. And so, yeah, so like the reason why I'm recommending that we keep a record of, the fact that we, provided the, notices, there is a, violation. So it does carry a penalty. There's some of these requirements that don't require, that don't have a penalty for a violation. So it's like, okay, we should do it. But at the end of the day, you're not being penalized. But this is one of those things where you could be penalized. And then the other thing that was kind of stuck into this one, that was in a lot of the, news articles when this passed the legislature and was signed by the government, is a slight change to emergency contact information. To basically include that if someone, as part of their emergency contact, they want to be notified when the employee is arrested or detained, the employer must notify that designated person if the arrest or detention occurs during work hours or during the performance of the employee's job duties. So again, that's just, if they have a designated emergency contact and we have knowledge of the person being arrested or detained during work hours at work, then we need to notify that person. And, I think what's helpful is digging into the weeds of, like, why are they doing this? Like, this is 100%, directed at, ICE raids and ICE visits, and basically, California responding and saying, hey, if there's an employee, and obviously it's written more broadly, so it would, contain any type of law enforcement arrest or detention. But, California is pushing this in response to, what's going on the federal level. So that's why it's there. I'll go to the next slide. So great question. Does the evidence of delivery have to be written, or can it be digital? And digital is fine. So, especially nowadays, a lot of things are emailed, they're onboarded electronically. And obviously, either way, if you're having someone onboard and initial every document and we're keeping that as a record, or you're sending it out via email and we're like keeping that is fine. Paid family leave expansion to designated persons. So in different areas of California law, the last few years with leave laws, particularly with CFRA, California Family Rights Act, leave, which is very similar to the federal FMLA, Family Medical Leave Act, which provides for medical leave for employees or their family members when they're needing to take leave for a serious illness or medical condition. In in a prior year, California changed CFRA to allow, and by the way, CFRA applies if you have five or more employees, and you have to allow up to 12 weeks of unpaid leave for a proper designated reason. But CFRA previously was changed to allow for a designated person. So that already happened with CFRA. And so basically, they're doing the same thing for paid family leave. They're expanding it to allow for a designated person, and designated person is defined as, someone related by blood or whose association with the individual is equivalent to a family member. So it could be a really close friend, that's akin to, a family member. And so just be aware of it. And obviously, if someone does that and they attest to under penalty of perjury, that's their relative, then or by blood or their designated person based on their associated family status or equivalence to a family status, that's something that they can do. So crime victims leave time off to attend judicial proceedings. And so throughout the years, there's been first California allowed for crime victims leave. And then there's been changes and additions to it over the law or over the last several years. And so just one of these things, like if you have your employee handbook, you have your policies for crime victims leave, just another thing that we need to make some minor changes to, and just be aware of it when it comes up. So basically, under prior law, if you have someone that comes to you because they're a victim of crime, or domestic, violence, obviously it's unpaid leave, and so we would have to excuse that for, court proceedings or, dealing with the situation. And again, and I say this in a sarcastic manner, but you don't know how many times people have asked me this question. But this applies to the actual victim. It doesn't apply to the wrongdoer or the person being accused of domestic violence. Like I've had people, well, or like I've had, people try to say, well, I'm going to use the crime, victims leave or a domestic violence leave, and they're the ones being accused. It doesn't work that way, right? So, if that ever comes up. But basically, under this new law, broader sense of crime victims leave, it allows for, victim, family member of a victim, time off to attend judicial proceedings, and basically moves the jurisdiction of that from, to basically the, civil rights department. And just keep in mind, a lot of us that have been around are used to saying the California Fair Employment and Housing Act. And the department used to be the Department of Fair Employment and Housing. It's now the Civil Rights Department. And so just be aware of that. And so obviously, if employees want to use vacation, another, paid personal leave benefit or paid sick leave, they can do that to cover the time, and get it paid. So jury duty leave. So, a lot of times, if you're looking at an employee handbook, there's a lot of various leaves that are kind of just briefly noted that, sometimes come up, sometimes don't. So under prior law, if an employee came to you and needed to take off work to do their civic duty of serving on a jury, we certainly had to allow for that, and allow them to do that. We had a slight change in law, and this one actually goes back to October 1st. And the new law requires an employee to provide reasonable advance notice of the employee's intention to take time off unless the advance notice is not feasible. Removed prior requirement that prior to taking the time off to serve on a jury, that the employee must give reasonable notice to the employer that the employee is required to serve. And of course, they can use, leave, benefits to cover that time. The main change here was adding in unless advance notice is not feasible, right? So, Obviously we want people to give advance notice, just having gone through jury service, as we all might have been called at some point or almost called as like, the local courts do, tend to give advance notice, but obviously, sometimes what happens is people are asking for continuances or things like that, or they forget about it, and this is one of those things I would just, you know, because of this change of law, advance notice is not feasible. I mean, unless we can really stick our hat on something, I would just be leery of taking adverse employment action against someone because this is a protected issue for obvious reasons. So just be aware of it. Expense reimbursement and employees and independent contractors. Um, so like crime victims leave, does family member of a victim include distant relatives? And so there's a definition under the crime victims leave of what constitutes a family member, and so depending on what the relation is, um, it's going to fit that definition, or it's not. And what I would say is just like use some common sense too, like based on what the person is saying, and if they're a victim of an actual crime and they don't have anyone else that can help, I would just use some common sense. And usually we can tell, right, is the person legitimately needing this leave? And it's unpaid leave, and so usually when it's unpaid leave, people are held accountable because at some point they need to come back to work and make money and get paid, right? Versus someone's abusing it, lying, taking advantage of the situation. And usually you can pretty much tell. And if they're going down that path, you can hold them accountable by asking for some proof, things of that nature. So getting back to the expense reimbursement on employees and independent contractors. So broadly under California Labor Code Section 2802, that's the code section that applies that basically if an employee, incurs a reasonable reimbursement on behalf of the business or company while doing work for us, that we need to reimburse for that, right? So it could be cell phone use, could be personal vehicle use, all for work reasons, right? And so what this one is kind of aiming at is they're going after independent contractors. And again, going back to California, changing the independent contractor test several years ago with the AB5 and the ABC test. Like this is just, making it harder for some industries to classify folks as independent contractors. And with respect to, construction, trucking, a commercial motor vehicle driver who owns the truck, trailer, tractor, or other commercial vehicle used for their duties, and employees entitled to reimbursement for the use and depreciation of that truck. So yeah, so generally, if you're operating a personal vehicle for business reasons, most companies are going to pay you mileage at the IRS reimbursement rate, which kind of also builds in reasonable use, wear and tear on the vehicle, along with gas reimbursement. And that's just the easiest way to do it. But this is really going after is there's a lot of folks that are operating as an independent contractor, and one of the facts that they've been using is, hey, I own my own truck, I own my own vehicle. So that's one of the factors looking at whether they're an independent contractor or employee. And so now this clearly saying that just because you happen to own your own vehicle doesn't help you in saying that you're an independent contractor. It would go into more of a are they actually a business? Do they employ others? Do they do business for other companies, not just this one? Do they have a business license? Do they have insurance? And so it's really going after those independent, those one person saying they're a business. And so obviously I know there's folks from different industries. I had this conversation at one of the local farm bureaus, before the holidays, where in ag, it's more of a thing where you have, folks coming to you as a driver, and it's really risky now because, more and more what California wants to see is if we're doing business with a quote unquote independent contractor, there really should be, a business license. They should be able to meet the business to business exemption. And if you're in a certain industry like construction, trucking, ag trucking in general, it's really hard to justify, having employees that are truck drivers and then also these one-off independent, contractors that are driving, essentially doing the same thing as an employee. It doesn't really pass the ABC test. So just be mindful of it and just be mindful of those that you're doing business with, making sure that they're on the up and up. Just last thing I'll say about this is where this comes up is if you're ever being audited by the EDD, they do a two-part test. And the first part is pretty straightforward. Did you do your employment taxes properly? Did you report that properly? I've only had one client screw that up over the years, and it's because they weren't paying the owners and enough salary to kind of justify what they were doing. But the second part is usually more contentious, and where people get tripped up is they want to look at your 1099s. Okay. And just from a practical standpoint, you might want to do this yourself and just see if you would pass the smell test from the EDD. Is they go through, and they look at Gazebo Gardens or Sagastra Watkins and Wheeland or whatever LLC and Inc. Like they're not worried about those, but the ones that don't pass the smell test, or if it's John Smith with the social security number, Ian Whelan with social security number, they're like, okay, who are these people? They don't even have a business. They don't even have, it's just a guy with a social. And then they really question those, right? And so historically, we would go into the factors of why they're a business. But I think more and more, in there might be some legacy folks that we do business with. And so, what I've seen a lot of clients do is just go to some of these people of like, hey, we like doing business with you, and you might be a handyman, it might be a janitor, but you really need to raise your level of sophistication here, and you need to become an LLC, and get a business license and get with the times, and we need to have a legit contract with you, because if we get audited by the EDD and it just says, John Smith and a social, like they're going to question that. And I've also had people that were doing like handyman janitorial services for clients, and it was there is, no business to business relationship where they've tried to flip it on the business and say, oh, I was an employee and you should have been paying me as an employee, when we all know that wasn't the case, and trying to take advantage of the situation. So just be mindful of it generally. So one of the, questions is, does the mileage reimbursement cover vehicle depreciation for an employee that runs a lot of errands? And so this question might have come up, before or like after I answered it. But anyways, um, use the IRS rate for mileage reimbursement, because the IRS rate, has baked in the wear and tear on vehicles. And so if you're using the IRS rate, you're pretty covered for the use of personal vehicles for, all things. For the errands that are being run on company business, going to meetings for company business, things like that. Every once in a while, I will come across a client that's doing something different than the IRS rate. And unless you have like really legitimate reasons, I'm always like, why are you doing this? Because, you're making it harder on yourself. And if you're ever questioned, we have to justify it. And so I think it's just easier to use the IRS rate. It's easy for someone like me to defend you if there's any issues. So just real quick on this next slide, amendments to the Fair Employment and Housing Act regulations regarding use of AI and employment. And so, and kind of laughed about this one, because if someone called me a year ago and asked me about this, I would say like, duh, yeah, you can't use AI to discriminate against people, or if you're using AI software that makes automated decisions and regarding hiring folks or employment decisions, and they have a discriminatory outcome, yeah, that's not going to be lawful, right? And so to make it super clear, the Civil Rights Department now has amended regulations making it clear that just because you're using AI and AI software to make employment decisions, that's not an excuse, and you still need to make sure there's not a discriminatory outcome, based on a protected characteristic like race, gender, age, things like that. And so obviously if you're using, AI to help you with things, you still got to look at the outcome and can we justify this from a business standpoint? And are there, in other words, are there legitimate business reasons why we're doing this? Because if you do a certain outcome, like sometimes, folks will, where this comes up a lot is reduction in force layoffs. Always, ask the client, let me see who's being targeted for layoff versus not. And we want to make sure we're not like laying off, mostly, women when there's very few women compared to the male employees, or based on race where there's really one race is being impacted more than the others. And most of the time that's not an issue because we're looking at it and we're using neutral criteria, or we're looking at folks that just aren't performers and going through that. But obviously just something to be mindful of if you're using AI software to help you with those sorts of decisions. So, um, yeah, went through that. It's kind of funny. Different groups. You know, um, it like literally I did a similar presentation in front of a farm bureau, and there was just a lot more questions. And I went over and I went on, and we had about an hour today, and like that one was like 2 hours, right? So I was able to kind of cover the same material in less than an hour, which is good for everyone. And just be mindful. Like I went through the main things. There are some other industry specific changes. For example, if you're in agriculture, there's some things that apply to you specifically, construction, things like that. So just make sure you do a check-in on those. But I also wanted to leave some time open. So if anyone has Q&A, this is the time. Like feel free to ask, and if you have questions about anything employment and labor while I'm here, like feel free to ask away.
One that just came in is, can employees be salaried and non-exempt, or do they need to be hourly?
So great question.
Mhm.
So yeah, you can have salaried non-exempt employees as long as you're making sure you're also keeping track of their hours, worked, and that they're getting paid, at least the minimum wage for all hours worked. And so for obvious reasons, I mean, I have certain clients in certain industries where it might make sense to do that, but generally, if someone, is going to qualify as being exempt, meaning they're salaried, and we're not having to track their hours, a time card, not having to worry about overtime or tracking meal and rest breaks, there's no reason to do that. And then if someone is going to be, non-exempt, most employers will just pay them on an hourly basis and track their hours and overtime and meal and rest breaks, and just, it makes it easier. I see people that get into trouble when they do hybrid models like that unless they really need to. Next question is really easy. Does the Warren Act count for seasonal employment? No. No. So if you have like have a lot of ag and ag related clients where we have seasonal employees and we have seasonal layoffs every year, seasonal layoffs do not count towards the Warren Act.
How about the next one? Can you expand a bit on the FMLA and paid family leave laws? I have approximately 25 employees and I'm curious about my responsibility for this and employees' rights.
Okay.
That's a big question.
That's a big question, and there's a lot there. And so I'll say, like, first off, you say you have approximately 25 employees. So anytime, it could be an existing client, it could be a new client, and it's someone I haven't heard from in a while. I always ask, like, during the call, if they want me to do an employee handbook or they want me to do some policy, how many employees do you have? And that, and there's some laws that are triggered if you have 10 or 15 employees, but you know the way that I was explaining to a newer member of the team this morning is, hey, if you have one employee, there's certain legal obligations. You have five, you have 25, you have 50. And there's some laws that have different, but the main ones are 1, 5, 25, 50, more than 50. And so what I would say first off is like figure out like, are you at 25 or are you below 25? Are you above 25 or do you plan to hit 25? And so we should just act like we're 25 because I have some clients that are on that threshold and they intentionally stay below 25 because there's all these leave laws that apply to you if you're at 25 or more, whereas they don't if you're below, 25. But your main question about paid family leave. So paid family leave is a benefit, generally through EDD that people can qualify through, like unemployment, disability, that they have to, affirmatively go and request. But what's similar to that, as I mentioned briefly, is there's the federal FMLA, which applies if you have 50 or more employees. And then in California, CFRA, which is five or more employees. And, we could talk about CFRA and FMLA for 2 hours, but like the main takeaway that you should know if you have five or more employees, CFRA is something you have to comply with, which is basically allowing employees to take up to 12 weeks of unpaid leave to care for themselves or a family member for a medical condition or serious illness. Also baby bonding. And it's 12 weeks. And then when they're gone for that 12 weeks, it's up to 12 weeks. They can take it intermittently or in smaller increments, but we have to keep their job or similar position open. Um, and basically, um, we can't. So if they come back after the 12 weeks, we have to reinstate their employment. So it's a serious deal. And if you need more information, I would just make sure you're up on that. And then if you're at 25 employees, there's a lot of leave laws that apply to you that you should be aware of and up to speed on. Um, so next question. We have some employees that are negative in PTO. Based on the new law, can we not require them to pay us back upon departure? So, so yeah, so basically, and this is a little bit different because what that new law is really going after is employment agreements that require employees to, pay us back, based on the written agreements that we have, right? And I use some examples. So in this situation, though, it's a bit different because you've allowed employees to go negative in their PTO and so yeah, and so I mean, even if you were doing this previously, the reality is you allowed that, and you unfortunately, unless you set it up as a separate loan agreement, which would be really tricky in this situation. There's really no legal basis for you to go and recover from the employee if they're negative in their PDO, like their PTO, and asking them to pay it back. That's just one of those kind of no good deed goes unpunished sort of things. If you're and the reality is, in a lot of situations where I've had clients go after employees for a little bit of money, it's kind of like we're throwing a lot of good money after bad money. It's like we're not going to get a return there. You can go to small claims and different things, and a lot of times it's just not worth the fight. Um, Next one, can you restate what was said about commissions and the minimum wage? So yeah, so like I said, kind of need some more information on what exactly how the employee is being paid commissions. And so one thing that I should say is if you're paying any employee based on commission in California, the law since January 1, 2015 has been there needs to be a written commission agreement signed by the employee. And so, I see sometimes people still come in the office and they're paying people based on commissions and there's no written agreement signed by the employee. And that's problematic because we're required to have it. And we get into this, like he said, she said situation about what the deal is. And if there's a discrepancy, they're going to side with the employee. And a typical commission agreement should define when is the commissions earned and when they're paid. Are they paid if the in-person leaves? Are they not? And so on your question, if someone is an outside salesperson, so they're spending more than half their time doing outside sales. And that's something, if you're not sure if you should get legal counsel and HR help with, technically they can, just earn what they get on commissions. They don't have to be paid at least minimum wage. However, if they're inside sales or they're doing another job that's based on commissions and they're being paid, they don't meet the outside sales exemption. They're being paid on an hourly basis, and it could be hourly plus commissions. They need to be paid at least the minimum wage for all hours worked. Um, and it sounds like if you have more follow-up questions, I would urge you to, contact your legal counsel or your HR professional and make sure you get dialed in on that. What is the legal definition of seasonal? And so, yeah, like with seasonal, and this is a great question. I actually love this question. Um, it's basically on the onset, you're telling the person that this is just only a limited short-term employment for a certain period of time, and that could be it could be and like a lot of times in ag, it's just general based on certain months, whatever. And I think this is really important is when we're onboarding employees on their new hire documentation. If they're seasonal, we should put seasonal. If it's full time, we should put full time, regular employment. Because I've had a lot of cases in ag and ag related where I'm defending an ag employer. And the reality is a lot of times it's Southern California plaintiff's attorney that isn't as familiar with ag and the seasonal nature of it. And I'm having to explain to them and defend like, no, we didn't fire your client because they had a protected issue or they took a leave. Like they're seasonal. They worked for us for 10 years and we lay them off every November, around the same time, plus or minus 2 weeks they get laid off, right? And so I think to help with that, what I've been telling folks for several years is on all your seasonal hires, put on their paperwork that they're a seasonal employee to make it easier, to, address any concerns from a would-be plaintiff's attorney or government agency to make it super clear, like this is seasonal. It's only for a, certain part of time with no expectation of continued employment past the season. And then the other thing too, right, is sometimes we have seasonal employees that transition into regular employment, and I think it's good to have some paper there of like, hey, this person transitioned into a regular full-time job, make them an offer into a regular full-time job and kind of have some paper like to back that up. But appreciate the question.
I think we got to the end of the question stack right at the exact right time. So Ian, as always, thank you for doing this. You really are. The thing that I love about how you approach this is that you approach these issues in even a way that an old landscaper like myself can understand, and really grateful. As a reminder.